"What's wrong with you?" my client said to me. "Why are you being so nice to your opponent?" You want to know what that's all about and what prompted that outrageous call? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. All right, this was a medical malpractice case, and now we had just been through 2 years of litigation and we were approaching trial. And before we ever got to trial, the defense did everything in their power to ask the judge to throw this case out. It's known as making a motion for summary judgment. And now what that really is it means we have to have a trial of this case, but just on papers. And now I have to spend many months, hundreds and hundreds of hours, to reply and to oppose the defense's request to throw the case out. And after submitting all of my documents, the defense then had an opportunity to give one final reply. A few months later, we get a decision from the judge in my favor, which means that the case would not be thrown out, that there were questions of fact that needed to be decided by a jury. So I won the motion, meaning the motion for summary judgment, the request to dismiss my client's case, was denied. So now the case proceeded on its way towards trial. I told my client, I said, listen, we were successful in defending this request. And she was very pleased to know that her case was not going to be dismissed prior to trial. So what was it about this call that prompted her to go ahead and start yelling at me, asking me, how could you be so nice to your opponent, to your adversary? What happened was that I needed information and certain documentation from my opponent. And, as is often the case, despite the fact that my opponent represents the doctor or the hospital, I am required. There's rules in New York that requires me to be civil to my opponent. I don't have to like them. I don't have to be buddy-buddy with them. I don't have to socialize with them, but I am required to be civil. And the reason why that rule and regulation came about is because for many, many years, there were many attorneys who had the school of thought that they had to be nasty and obnoxious and arrogant to their opponent, that this was a fight to the death, that they were on opposite sides of a case, and therefore they would get no quarter, meaning that there would be no courtesies extended, that there would be nothing. Everything you want is going to be a fight. You say the sky is blue? No, it's not. It's red. You say it's 10 o'clock? No, it's not. It's 5 o'clock. Every single little thing you are going to fight over. And that's how it used to be. And that was very, very frustrating, not just for the litigants, but for the attorneys, for the office staff, and everybody involved. It was a toxic environment. And finally, the court administration in New York got fed up with this, and they formulated an actual rule that said lawyers who deal with each other as opponents are required to be civil with each other. And again, you don't have to be friends, you don't have to be buddies, you don't have to go to lunch with each other. However, you have to be professional and civil. And if you're not, there are going to be penalties and repercussions for the attorney who actually violates that rule. Now you would think, I don't understand. Why aren't attorneys just good people? Well, the same could be true for anyone in any profession. There are always bad apples in every profession as well as every service industry. So you have to ask yourself, okay, you have a job to do, meaning I have a job to do representing the best interests of my client. The defense also has an obligation to represent his or her clients to the best of their ability, and no one disputes that. However, from a litigant's standpoint, from someone who participates as a party to the lawsuit, you believe in your mind that you are 100% right. You believe that your version of the events is totally right and the defense's version is totally wrong. And you cannot fathom, you cannot imagine that the attorney who represents the other side, that there's any possible way you could get along in any fashion because they represent everything that you don't. They represent the opposite of what you are claiming. So in that instance, you can't fathom and can't understand how it's possible that the defense attorney could actually have a pleasant relationship with you. And that is absolutely true. Despite the fact that I am opponents with these defense lawyers, I will tell you that I happen to have good professional relationships with almost all of them. And I say almost all of them because there are occasionally one or two that crop up from time to time that don't really adhere to that rule that I just mentioned earlier. And in that instance, they become a problem and a thorn in our side. But for the most part, despite the fact that we are on opposite sides, I am required to be pleasant and civil to my opponents. And when my client heard this, she was outraged. How could you do that? They're fighting against us. They're trying to do everything possible to minimize the value of my injuries. I don't like the fact that you are now talking to them in a pleasant tone and you're being nice and having a request to extend the time to do something. I just don't like that. And I said to her, I understand your frustration. I recognize that you are frustrated not only because you suffered these injuries, and you strongly believe, as does our expert, that the people whom you have sued are responsible for your injuries. I totally get that. But as an attorney, I have an obligation to work with my adversary, which means that if my opponent calls to tell me, listen, I have to make this formal written request to the judge to take action on this case. Can you give me some additional time? I'm going away, I just had a baby, or whatever it is. Can you give me, or will you agree to give me some additional time? And my response in almost every case is yes, not a problem. Because there are instances where I have to do the same thing, where I will call up my adversary and say, listen, I'm swamped, I have all these other issues and all these other cases to deal with, and now I can't get to this particular issue right now. Would it be okay if I get your consent to push this back a month? Can we push it back 2 months? Can we do the deposition a little bit later? Can we move this one up earlier? And in most cases, my opponent will work with me. Why? Because it works both ways. So these are minor, trivial points in which we have to work with each other. But my client perceived this almost as if I was betraying her. And that was quite eye-opening to me. She thought that because I was being pleasant and professional with my opponent, that I was betraying her, and somehow I was working against her and against her interests. And the reality was that nothing could be further from the truth. There was no way I was going to waver in our shared interests to try and obtain as much compensation as possible to get her the best possible outcome I could in her particular case. But she did not perceive it that way, at least initially. Once I began to explain to her what I'm explaining to you in this video, she began to soften and recognize, okay, they're human beings too. They're doing the job that they're required to do. And you know the phrase, oh, it's not personal? Well, I don't believe that phrase. I think it's all personal. It's personal for my client, it's personal for me, because every interaction that I have with my opponent is personal. I've gotten to know things about their family just by communicating with them. I've gotten to know things about their personal lives just by communicating with them. And it does not detract one bit with how I represent my client and her best interests. And that's something that my client didn't understand. And I think a lot of people have that misperception that if we are pleasant with our adversaries, it must mean that we are somehow betraying them and not working in their best interests. But the reality is totally different. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.